There's just no way that banning the Ten Commandments from public places is a consistent application of any legitimate reading of the Establishment Clause in the First Amendment. Like, if the establishment of religion is somewhere up here, then we have like the reading of the King James Bible, reciting Christian prayers in school, like the posting the Ten Commandments, which is a founding legal and religious symbol in America. That's like way down here. We're not even close to an establishment of religion, just not even close. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. A couple of big legal cases today, so we have a lot to cover. This week, we'll be covering the Louisiana Ten Commandments case that has made its way up through the Fifth Circuit. We had a recent ruling en banc from the Fifth Circuit there. We have a disturbing case in Washington state over a law that would allow children to run away from home and essentially receive sex-rejecting treatments without parental consent. And then we'll finish up with a court judgment in the Mahmoud case in Montgomery County, Maryland, ordering the schools to pay damages to parents whose parental and religious exercise rights were violated by the overturned policies there. So let's start in Louisiana. We have an en banc opinion that was issued on February 20th in a case called Roque versus Brumley. I hope I'm saying all that right, which is based on a law that required the display of the Ten Commandments in all public schools. And the Fifth Circuit en banc opinion affirms that law as not in violation of the Constitution, at least at this time. So we'll get into what's going on there. This started when Louisiana passed House Bill 71, which mandates the display of the Ten Commandments in all classrooms. And after the law was passed, it was challenged pretty much immediately on the grounds that it violated both the establishment and free exercise clauses of the First Amendment. The court in the Fifth Circuit here held that the case was not fit for judicial resolution at this time. So we don't get a decision on the merits of the constitutional claims, but the law does stand for now. And that's what I want to spend the rest of the time talking about, the reasoning and the differences of opinion here. So the majority's reasoning is that while the Ten Commandments have an immense religious significance for believing Jews and Christians, obviously, the court also holds that the Ten Commandments have another role in the legal system, right? Creating a dual character in the Ten Commandments, right? They have religious significance, but they also have historical and legal significance apart from their religious value or symbolism. And because they have that dual character, as the court calls it, this forecloses any categorical rule against their display. So the court goes on and talks about how the law gives a lot of discretion on how the Ten Commandments are supposed to be displayed and how they are to be used in the classroom. That discretion is given to individual schools and school boards, which means that the court is unable to rule, supposedly, on the constitutionality of the law. So what the court is saying here is there's no evidence of misuse or unconstitutional practice in how the Ten Commandments are being displayed in like a religiously impermissible way, I suppose. And so, because we don't have any concrete examples of how this law would violate the Constitution in concrete cases, courts don't have the ability to deal with a constitutional issue in the abstract, only in concrete cases and controversies. So, because of that, the court says we really can't resolve any constitutional dispute at this time. So the court rejects the claim that the law itself violates free exercise or the Establishment Clause because without a fact-intensive discovery backed up by substantial evidence, the court can't prove that the law substantially interferes with the religious development of a child. So the case is almost certainly going to be relitigated after schools do actually start implementing the law. But I do want to discuss a couple of the legal things that I think are going on here. First, the majority opinion allows the Ten Commandments law to stand, but on grounds of ripeness, not on the constitutional merits. And I want to read from the opinion here. Quote, asking us to declare here and now and in the abstract that every possible HB 71 display would violate the Establishment Clause would require precisely what Texas forbids, the substitution of speculation for adjudication. It would oblige us to hypothesize an open-ended range of possible classroom displays and then assess each under a context-sensitive standard that depends on facts not yet developed and indeed not yet knowable. That exercise exceeds the judicial function. That is not judging, it is guessing, end quote. So I get what the majority is saying here, right? That we don't know if any of these displays would violate the First Amendment because there have been no displays yet. So you can't say that this law in itself, without actual application, violates the First Amendment. There is a counter analysis that would get to this case being decided on the merits even now before implementation. And that's worth mentioning because Judge James Ho, who is a conservative celebrity on the Fifth Circuit bench there, wrote a concurrence in this case, arguing that the district court ruling should have been vacated on the merits, not on ripeness. So I want to talk a little bit about that. First, there's an interesting argument worth reading here. And if you're interested in this topic, you should read through it because I can't get to all of the legal reasoning. But what Judge Ho says, first of all, is at the end of the day, the opponents of the law, their main legal argument essentially relies on Lemon. Well, relies on a line of cases that rely on Lemon, and Lemon has been overruled slash abandoned explicitly in Kennedy versus Bremerton. Apparently, before that, we don't know, but in Kennedy, it was announced that that Lemon has long been abandoned, and so you can't you can't cite Lemon as your your argument for the unconstitutionality of anything. So Judge Ho then goes on to take apart this uh, related argument that supposedly religious displays in public like this are somehow coercive to non-religious or objecting people. And he goes through a plethora of cases. Again, if you're interested, read the case. It's a good tour de force of how far we've gone astray on this argument. He cites cases regarding public nativity scenes, other Ten Commandments displays, a daily recitation of the Pledge of Allegiance in public places. Says these are not coercive to non-religious people just by them being there. And he actually goes on to say that, listen, we've upheld the Pledge of Allegiance, which is spoken, right, every day. It's a monotheistic creed, right? One nation under God. Non-religious people in schools have to hear it even if they don't participate every single day. And so, in fact, the Ten Commandments being passively displayed in a classroom is actually much less coercive or in your face than things that we've already upheld, like a daily Pledge of Allegiance. So the coercion argument's out of the way. The Lemon argument is dead. And then Judge Ho gets to the heart of the matter, in my opinion. None of what I'm about to read from this opinion should be unfamiliar to listeners of this podcast because I sound off on it all the time when we talk about the Establishment Clause in particular. But I do want to quote Judge Ho because I think this gets to the essence of the argument and will probably be pretty relevant when this case comes back up on the merits. So here's the quote. Quote, once stone is removed, it's one of the cases that the opponents of the bill or of the law are relying on, that this case should be easy to dismiss. Plaintiffs present no historical evidence that remotely suggests that our founders would have regarded a passive display of the Ten Commandments as an impermissible establishment of religion. To the contrary, our nation's history proves precisely the opposite. Our nation's founders didn't just permit religion in education, they presumed that there would be religion in education. Indeed, our founders firmly believed that our Constitution wouldn't work without a religious people. He then goes on to quote John Adams, right? This Constitution was made for a moral and religious people, and it's wholly unfit for any other, and so on. But I think his argument's important, both because it's going to come back up and because it really reiterates the true meaning and limit of the Establishment Clause, right? And so the gist of his argument in the concurring opinion is the passive display of the Ten Commandments, both as a legal or historical symbol, but also as a non-sectarian religious symbol. Worth pointing that out, right? Is not It's not a Baptist display, it's not a Catholic display. All Christian denominations, as well as Jews, and in a certain sense, Muslims, value the Ten Commandments. So it's not a sectarian religious symbol, and this just does not come close to an establishment of religion. Right? As I've said ad nauseum here, the first public schools in the 19th century in America, they read from the King James Bible. They recited the Our Father in class. There's just no way that banning the Ten Commandments from public places is a consistent application of any legitimate reading of the Establishment Clause in the First Amendment. Like if the the establishment of religion is somewhere up here, then we have like the reading of the King James Bible, reciting Christian prayers in school, like the posting the Ten Commandments, which is a founding legal and religious symbol in America. That's like way down here. We're not even close to an establishment of religion, just not even close. Um, so I'll turn it over to you, Joseph. But I would just say when these laws are implemented and schools do start displaying the Ten Commandments in Louisiana in accordance with HB 71, I do expect we'll see another round of litigation. And I do expect the reasoning in Judge Ho's concurrence to then come to prominence when the issue is actually argued and decided on the constitutional merits, because I think he's spot on. I think his reasoning is correct. I hope this will prevail at the Fifth Circuit and start to set up some continued precedent, right? We already have cases with crosses at, veterans memorials and things like that. So, but I would hope that this will be another opportunity to further fix the meaning of the Establishment Clause to say the Establishment Clause means you can't establish one denomination or one particular church over another in the government. It does not mean that you have to wipe religion out of the public square.
Yeah, absolutely. Thanks, Frank, for explaining this case. And I'd love to spend just a minute on explaining how the old Ghoul of Lemon kind of shuffled its way back into these concurrences and dissents here. So there's this Supreme Court case from 1980 called Stone v. Graham, and it's factually pretty similar to this one. Kentucky passed a law requiring the Ten Commandments to be posted in every public school classroom, pretty quickly challenged based on Establishment Clause grounds. Now, in the case in Stone, the court decided that Kentucky's law was likely a violation of the Establishment Clause based on the first part of the Lemon Test. And under the first part of the Lemon Test, basically there must be a secular legislative purpose in whatever's being challenged. Is there a non-religious reason to pass this law, right? Now, in Stone, the court said no, Kentucky's law didn't have a secular legislative purpose, which personally I totally disagree with. Even under the Lemon Test, there is absolutely a secular purpose to put the Ten Commandments in public school classrooms. Like you said, Frank, it's a fundamental moral, yes, religious, but also just more broadly moral and legal document that's kind of really framed the basis of Western morality since, I mean, they're first being handed down to the Jewish people. But basically, the court said no, there was no secular legislative purpose because posting the commandments would only kind of cause kids to venerate and obey the commandments. There would only be kind of this religious animus. However desirable this might be as a matter of private devotion, the court said it is not a permissible state objective under the Establishment Clause. Now, like Frank mentioned, in 2022 in Kennedy v. Bremerton, that's like basically a coach wanted to pray after games at a public school and it went to the Supreme Court. In that case, the court finally formally said we have long since disavowed Lemon. Um, Now, in the dissent here, the way Lemon is being brought back up is that the dissents are claiming that Kennedy only formally dismissed one part of Lemon, and it's the endorsement test, which basically says would a reasonable observer view the challenged activity as an endorsement of religion. They're saying that Kennedy only got rid of that part of Lemon. Stone didn't rely on that part of Lemon. Therefore, Stone should control in this case. But that's just a blatant misreading of Kennedy. If you read the actual opinion, it's very obvious that the court has said all of Lemon has long since been disavowed and overturned. Kennedy itself says this court long ago abandoned Lemon and its endorsement test offshoot. It's not just Lemon or the endorsement test offshoot or just the endorsement test offshoot. It's very clear that it's just kind of the entire logic of Lemon has gotten discarded with. And as a lot of our listeners probably know, over 30 years ago, Justice Scalia, in one of his kind of best written dissents, he's got a lot of great ones, but he wrote that like some ghoul in a late night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried, Lemon stalks our Establishment Clause jurisprudence once again, frightening the little children and school attorneys of this particular district that was being brought up in this case. It says, over the years, however, no fewer than 5 of the currently sitting justices have, in their own opinions, personally driven pencils through the creature's heart. So like Frank mentioned, while this is right now just on ripeness, it's not getting to the merits. It likely will be litigated in the future on the merits. And hopefully at that point, we can drive a couple more pencils through Lemon and bury it a few feet deeper.
Yeah, the story of the death of Lemon, I won't go into it in too much detail now, but it is funny that, like Justice Scalia said, it's like they keep trying to kill it or chip away at it and kill it and chip away. Like it's a bad test. People wanted it gone for decades. And then it's kind of funny that it's Kennedy v. Bremerton that got rid of it. I just spoke at a symposium where Coach Kennedy spoke, and so I got to meet him and was talking to him at dinner the night before. And he's like, he's just a guy. He was a Marine and a football coach, and he's like, I just thought I was praying. Like I just took a knee and prayed after each football. I didn't know that I was going to be the one to bury Lemon, and now my name is on the case that finally got rid of the Lemon test. So, kind of an interesting fate that after this thing kept coming back and coming back, that what killed it was actually not a direct attempt to kill the Lemon test. But there you have it.
Then with that, we'll move on to our second update. Next, we'll be discussing a case currently pending before the Supreme Court that's challenging a set of Washington state laws that basically enable kids to run away from home and receive sex-rejecting procedures and drugs without parental consent, and even in some cases, parental notification. So basically, the facts: there's a couple state laws in Washington, most of which were added in 2023, that essentially cut parents out of the loop if their parents or if their kids run away to youth shelters that seek out, as defined by the laws, "quote unquote" gender affirming care or "quote unquote" reproductive services. As we know, these are just misnomers for abortions, mastectomies on healthy kids, overdosing cross-sex hormones, all these things that are either irreversible or have a lot of scientific research backing up kind of the idea that they are irreversible. Um, so while some of the language and immediate implications of this kind of set of laws in Washington state law are a bit confusing and they're worded kind of awkwardly, ultimately these laws function to let state-run entities hide and facilitate operations on kids that run away from home without needing to, in some cases, even tell the parents that what's going on in the first place. In other cases, needing any consent from the parents. Shelters holding kids seeking out these procedures and drugs don't have to immediately notify parents if they fear this undefined um, prospect of abuse or neglect from the parents. That could mean that the state thinks that not letting your kid, cut off healthy body parts is abuse or neglect, and then you have to tell the parents what's going on. So, what's the primary legal challenge? As you can imagine, a group of parents that have been negatively impacted by the law filed a suit against it. And all these parents have kids that struggle with gender dysphoria. Some of them work in kind of different ways than others. One set of parents has a kid that has already run away in the past because of the parents' refusal to, treat their daughter like a son or the other way around. Some of the parents have had other family members encourage their kids to run away. One of them even has autism, and their cousins or aunts or even siblings are saying, "Just run away and go do what you want." Many of the kids of the parents in this suit are at public schools that already treat the boys like girls and the girls like boys against the express wishes of the parents. So all these parents have, in one way or another, struggled with kids that have kids have struggled with gender dysphoria, and they're all in situations where they fear their kids can just run away again under these Washington state laws and just be treated like the opposite sex against the parents' wishes. And this is for kids aged like 13 to 18. So this is as young as it's like fifth grade or something like that, maybe middle school. So it's definitely no kid can consent to these kinds of things. And these state laws are basically making it so they can just run away and do what they want in a state sponsored way. So what are the legal claims going on here? There's three main things the parents are saying that these state laws do. For one, they say that it impacts the way that they parent. Some of the parents said they've stopped disciplining their kid for fear of upsetting them and driving them away to a state shelter. They're basically saying that the law has a chilling effect on a constitutionally protected right. So even though the right to raise your kids and direct their medical care is unenumerated, we've got a few previous Supreme Court cases that have declared the right to do these things constitutionally protected. So they're saying these state laws chill a constitutional activity, therefore they have to be kind of there's grounds to challenge them, right? The second is a little bit similar. The law has censored their speech. Some of the parents have stopped talking about gender for fear of driving their kids away. They've stopped using the kid's given name or given pronouns. And similar to the first claim, they're saying this is chilling constitutionally protected activity. And there's a little bit more jurisprudence fleshed out on the free speech claim. So that's a little bit more streamlined. And then third, the parents are saying that these laws limit their access to the medical information of their kids. Like I said before, the shelters that take in kids under these laws aren't always even required to immediately notify parents. Some of them haven't even received information still about their kids' hospitalization. Um, so right now, the case actually centers around standing. The district and circuit courts dismissed the parents' claims, saying that the group of parents didn't face concrete, current, or future imminent harm as a direct result of these laws. On that first claim, chilling the right to parent, they're saying that's self inflicted. They're saying they're choosing to do this. The law doesn't actually make them. Pretty similar on the second claim, the statutes themselves don't say you're going to get prosecuted for your speech. And under the three, they've dismissed it because other laws are the actual ones that are restricting parents' access to medical information. So basically, by saying you're not actually being impacted by these because the law itself doesn't say you're not allowed to talk to your kids. That's more or less what the court ruled in the most recent dismissal at the circuit level. So that's now the challenge before the Supreme Court. It's kind of like the Ten Commandments case. It's not on the merits, but are the parents able to get their day in court? Are they concretely and imminently harmed by these laws? Um, and a group of states led by Florida and Idaho recently filed an amicus brief urging the court to hear this case. And they speak really well to the harm that the parents are facing right now and can face in the future. And there's a few kind of key phrases from this amicus brief that really just explain how these parents are impacted in such a way that gives them standing. The brief states that to parents, their right to parent their child as they see fit is everything. And the Washington law they are challenging abridges that right today, not kind of some abstract, fuzzy thing in the future. It abridges that right now, today, in a real way. Second, quote, the whole point of Washington's law was to change parents' behavior and undermine their ability to make decisions for their children. That one kind of speaks for itself. Lastly, quote, the state imposes adverse consequences for exercising a right. If the state imposes adverse consequences for exercising a right, then the predictable result is for right holders to forbear. Really, this all comes down to what is more important to parents than our children? And the answer is nothing. The Supreme Court has affirmed time and time again that the freedom to raise your kids is constitutionally protected. When the entire purpose of a law is to cut back a fundamental right, you have to be able to at least get in the courtroom door. And just one last key point that I want to close with from this amicus brief is that it really distinguishes this particular suit from other parental rights claims that have also failed at circuit levels and are pending before the Supreme Court, and just kind of speaks a little bit more to its kind of SCOTUS ability that it's a new type of claim. So, as I mentioned, there are a few different challenges to these basically exclusion policies at public schools. So, if a school wants to, or if a kid wants to be treated as a boy when they're a girl, or a girl wants to be treated as a boy in a public school, a lot of states basically say we're not going to tell the parents and we're going to do it on our own. It's parental exclusion policy is what they're known as now. There's a few different ones pending before the court right now. I think Foot v. Ludlow, Leon County. There was one in the emergency docket that hasn't seen any action in a bit. It's Mirabelli. But all of these different parental rights claims against these exclusion policies have failed for different reasons. But what's really unique about this claim is that this is bona fide medical activity. Most of the other claims are relying on substantive due process, saying, hey, this is a medical. The Supreme Court has ruled that the right to direct the medical upbringing of your kids is protected under substantive due process. Some courts have dismissed that in these other claims by saying, well, this is just using pronouns, this is just using names, it's not a medical activity. Here we have bona fide, clear medical activity. These kids are actually getting drugs, they're getting procedures, there's no dispute there. So that's why this case is a little bit maybe more SCOTUSable, because there's a clear contradiction of existing substantive due process case law. It's obvious that this is a medical activity, and it's obvious that parents are getting cut out. So if this does end up going on the merits, going the substantive due process route, it's more directly kind of tied to previous SCOTUS case law and more contradictory of it. So this could be a bit of a cleaner vehicle for the court to further protect parental rights. So Frank, that's what I'm seeing. I'd love to hear your thoughts on this one.
Yeah. It'll be interesting to see if SCOTUS takes it and how they will use this fact pattern, which, like you said, because it involves medical treatment, is a pretty good one to maybe advance parental rights jurisprudence. I just want to back up and talk about the mechanism because it's so troubling to me. As I worked for a children and youth agency as government counsel for a couple of years before I was at Napa Legal, and so this is so disturbing to me on the way that this is being implemented. So to have, well, two things. For one, you can see we've seen it in California and some other places, these aggressive and inappropriate uses of child protective services to go after parents basically who don't agree with their children's, attempts to identify as a different gender or identify as, same-sex attracted, whatever. The classifying something like this, right? A parental concern for mental health issues with their children, not affirming their child's mental health issues as a good, classifying this as child abuse or neglect is just wildly inappropriate. Um, I know there have been some attempts. There need to be more. I know Texas, the attorney general at one point issued guidance saying that, gender affirming care, refusal to provide the so-called gender affirming care is not child abuse. There have been some states that have tried to introduce legislation, but that I think 100% needs to happen. Statutory, clear language saying refusal to acknowledge a child's, transgender identity claim or LGBT status is per se not child abuse or neglect. I think that should absolutely be clear law. But even that is a step beyond what's happening here because my point is there's a mechanism in every state law where if a child is being abused or neglected by the parents' decisions or lack of decisions, um, you have a court system set up for this, right? You have juvenile courts where, somebody files a petition from the state agency and it goes before a judge and the judge can rule and say, yes, there's evidence here that the child is being abused or neglected and therefore, the state is going to take this as a dependent child and, foster parent or somebody else is going to have some decision making rights because the parents have basically forfeited their ability to make decisions for the child's well-being. There's a court process for that. Here, In Washington, that's being trampled on, right? Because you don't even need a court process. Like, no, if the kid runs away and goes to a shelter, the shelter can just keep the kid there, not notify the parents. The kid can go get gender affirming care, and that is in scare quotes very much so. But that's so offensive because again, there's a process for this. It's supposed to be a very high bar before anybody other than the parent can step in and make medical decisions or keep medical decisions away from parents. So go through the process, right? If Washington really wants to go this insane route, then every time a child runs away from home, then it should be the duty of the shelter, right, to first and foremost report to Children Youth Services, right, report to Child Protective Services, and file the necessary paperwork with the court and have a court look at it and say, is there really abuse or neglect here? Rather than the shelter saying, looks like there might be abuse or neglect, so we're not going to notify the parent. That's just crazy. Because parental rights are so protected by law, it's understood that you need a court to weigh in and say, like, yeah, there's evidence of abuse and neglect here sufficient to warrant someone other than the parent making these decisions. This is a runaround that has no process, no due process for the parents at all before these troubled kids can go and make these terrible and life altering decisions. So no government agency should ever be making these decisions above parents because they're bad decisions on their face. But it certainly shouldn't be done by letting a kid run away and having no court due process at all before those can take place. All right, so we will quickly conclude by heading to Montgomery County, Maryland here, which seems like it's kind of an odd posture that we're talking about something happening in the Mahmoud v. Taylor case, because, like, hey, we disposed of this last year when the Supreme Court ruled on this. What's going on here? So recently, Montgomery County, Maryland, the Board of Education was ordered to pay $1.5 million in damages as part of a settlement agreement to parents that were represented by Beckett after the Supreme Court's decision last term in Mahmoud v. Taylor. So, if you remember, and I'm sure most of you do, Supreme Court ruled last year that parents have a right to direct the religious upbringing of their own children. Public classrooms don't have an exception to that right. And after that decision came down, the case was remanded to the lower courts to determine damages, require the school district to give parents advance notice of any inappropriate material that may go against their religious beliefs so that the parents can opt their kids out if they choose. So legally, it's just worth a brief reminder about why this just happened, the posture of the case. After Mahmoud was decided last year by the highest court in the land, the Supreme Court, why is this still ongoing in 2026? Well, Mahmoud was a ruling on a preliminary injunction, right? So the Supreme Court in Mahmoud last year held that the parents in the case were entitled to a preliminary injunction preventing the school district from exposing young school children to inappropriate materials without parental notification or consent and an opt-out option, right? Um, but what happened there is there was a fight for a preliminary injunction. It went up to the Supreme Court, and the Supreme Court said yes, likely to succeed on the merits. So the parents get the preliminary injunction. Then it was sent back down to the lower court, to the district court there for a final ruling. That's why we're here. So after the Supreme Court weighed in, gave its ruling, gave its reasoning, the school district still had to fight this out in the district court for a final ruling, and the school district did settle the case, which is why we now have an update. The school district agreed to pay the parents $1.5 million in damages and also agreed to a permanent injunction. So the settlement agreement provides the following. I'm going to just read here from this is from Beckett's website, who represented the parents. Quote, Montgomery County Board of Education must provide parents with advance notice when instructional materials addressing family life and human sexuality will be used and allow parents to opt their children out of that instruction. The agreement also requires the board to pay damages to the families and places the district under ongoing court jurisdiction to ensure compliance, end quote. So I know Joseph has more to say about this, but I think this is really encouraging. Constitutional rulings and laws are good. That's one thing. But when policies endanger children, families, and the common good, money talks, right? School districts might be willing to continue their ideological crusades even after the highest court in the land rules against them. We see things like this all the time. We saw in Carson v. Macon, right? The Supreme Court says, no, you can't exclude religious schools from your voucher program. And so then they change the requirement and say, well, we're not opposing religious schools. We're just opposing schools that don't, abide by our crazy non-discrimination regimes. So you see states or government, local agencies, whoever, constantly doing what they can to change the goalposts and get around court rulings or laws to advance what they want to do. But
Mhm.
when they're hitting the pocketbook, forced to actually pay damages to the victims of their ideological choices, that's an encouraging and effective way to stop the madness. I know you're going to talk about the Valerian Fox case. That's a good example. So I hope here this ruling also will send a clear warning to school districts that, listen, if you're going to expose children to dangerous and inappropriate materials, Supreme Court has said very clearly you need to notify the parents, you need to allow them to opt out. And if you don't, not only, well, you're in violation of the Supreme Court's jurisprudence, but no, you're going to be held financially responsible. Um, we've seen in a lot of situations that when you make these ideological crusaders pay literally for their choices, that's the way to end these types of things. So happy to see this and hope that this will send a message.
Absolutely. Like you said, Frank, this is reminiscent of that Barry and Fox case we had talked about a couple weeks ago at this point, where she had sued her former psychologist and former plastic surgeon that basically encouraged and then performed a double mastectomy on her when she was, I think she was like 16 or something like that. And then her psychologist told her, yeah, like you totally should go through this thing. You should act like a boy. You should physically change your body for the rest of your life so you can look like a boy. And then the doctor that went and did it and kind of ignored lots of red flags. She sued and won $2 million, um, and including a good sum for future medical expenses. And like you said, in a lot of these disputes, the reality is it's money that talks, right? In some cases, $1 million plus fines is the actual way to start winning the culture war and to start changing actual activity. If schools pushing sexual materials on kids won't listen to a court order, they'll listen to a seven-figure fine. If doctors won't listen to basic standards of moral and ethical and care, they'll listen to a shrinking wallet. Right. So while these big precedent-setting cases are really important to lay the foundation, if we never had Mahmoud v. Taylor, we would never have this payout and we would never have this permanent injunction where the school can't do this anymore to these kids. They're important, but these big dollar fines that effectively kind of carry out these precedents, that's what really can move the needle.
And the one last thing I'll say on that too is there is in our current system a role for the federal government to enact policy on this because the federal government is funding for better and for worse all of these state and local school districts and programs, right? So I would expect to see that in this case, Montgomery County settled. And presumably because they were the ones in the spotlight, we won't see them avoiding the Mahmoud decision, and they will just give the notice and the opt out provision. But I would be very unsurprised to see that if other school districts are trying to get around Mahmoud and expose children to these inappropriate kinds of materials without telling parents, that you may very well see the federal Department of Education weigh in and say, you're violating the Constitution by not respecting parents, religious rights and parental rights, and so we're going to take a look at your federal funding for your school programs. So that's an important tool in the fight, so long as the federal government sees fit to continue to take federal tax dollars to then give back to state programs. I don't think they should be doing that at all. But while they're doing it, they should certainly be doing it to make sure that good policies are being enacted by the state and local programs that they're funding. And with that, we thank you for joining us for another episode of the Napa Legal Podcast. If you enjoy the content that we're putting out, we always appreciate it. If you like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening from. If you want to see what we're up to at Napa Legal, we have a lot going on in these coming weeks and months. We're starting another year of the Good Counselor Project Fellowship for Attorneys this month. We are having our second annual National Lawyers Conference in Washington, D.C. in April. If you want to know dates, programs, events, what we're doing, if you want to support our work and contribute to it, you can find out more and support our work at napalegalinstitute.org. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and particularly the work of faith based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you.